it was a situation where we felt like our son's heart had gone astray. I think Jesus shared a story about he had 100 sheep and one went astray.
Shared immediately what he'd done, and so we were weeping, and the little one was like, "What's wrong? Why is Daddy and Josh leaving?" And Josh has done some very bad things, and he's very sorry.
I was thankful. The ray of hope was that Josh had came and told us, and that his heart was still soft.
Hey guys, it's Katie from Without a Crystal Ball. Welcome back to my channel. It's Wednesday, November 3rd. I hope you're having a really good day. Josh Duggar's defense is going to be falling apart. Actually, no, but the prosecutors in his case have some ideas about what he plans to use as his defense, and as a result, they have taken action in court today to have certain things admitted into the court and have other options of his that he wants to do not allowed for his defense. So we're going to talk about the first thing that I think is going to be the most relevant to many of you who are supporters of the sisters, because what Josh has publicly acknowledged to doing to his sisters and one other individual, the federal government wants to admit as potential evidence in court. So they filed in court what's called a limine, which is a addition, or they want to add something and get permission from the court as why this evidence, which is not necessarily exact evidence related to what the crime is, but is supporting evidence. And in this case, they want to use his public statements along with his investigation into what happened all those years ago as proof that it could have been only him that was downloading that content. So they basically argue that it has they say they hereby notice its intent to introduce at trial evidence that the defendant committed other acts of CM pursuant to the rules, evidence 404B and 414, moves in limine for the admission of evidence that the defendant engaged in other CM conduct states as follows. So CM we're going to use for what he did to his sisters and the other person, and this is their argument. Their argument is that he's charged in this indictment of downloading and receiving CSAM, and that basically they rehash everything about how they came to find the information, going into the car lot and obtaining this, and they get it off of his computer. But this is what they said, that he had argued, will attempt to argue at trial, that he was not the individual who used the HP desktop computer to download and view the CSAM, and he is not interested in that material. So they believe that one of his defenses is going to be, it's someone else, it's not me, and I'm not even interested in that. So they are saying, in light of that, they are anticipating the defense, that is a defense, and so they're saying, in pursuant to the federal rules of evidence 414 and 404B, they now provide the defendants with notice that it may seek to introduce evidence at trial that the defendant committed other acts of CM as that term and defined by Rule 414. Specifically, the government notices its intent to introduce evidence that in approximately 2002 and 2003, before he committed the offenses charged in the indictment in this case, and while living in Arkansas, the defendant attempted to and did commit a crime as defined by Arkansas state law involving contact between any part of the defendant's body and a child's area. And they say that under what he did, that it would be classified as SA in the second degree under Arkansas Code 514125. And they say if they introduce this, they anticipate the evidence will consist of testimony that the defendant was investigated for, admitted to and received counseling for touching an SM, multiple minor females, including at least one instance involving digital penetration. So in terms of why they want this, they go over evidence of federal rule evidence 414. They say that it's admissible because there's this act called Violent Crime Control and Law Enforcement of 1994, and it governs the admission of evidence of similar crimes in CS offenses, and that in a criminal case in which a defendant is accused of CM, the court may admit evidence that the defendant committed any other CM. The evidence may be considered on any matter to which it is relevant. They say 414 broadly defines the term CM to include federal or state crime involving any conduct prohibited under 18 U.S.C. Chapter 110 or contact between any part of the defendant's body and or the child's areas, or an attempt to commit a crime. And then they said the upshot of this rule is that evidence of a defendant's prior acts of CM is presumptively admissible to establish the defendant's propensity to commit the charged crime. So there's the law that basically says that if you are charged with something like this, they can bring in evidence that shows that you have either done something in the past that's consistent with the same crime. So it's the ability to establish a pattern of behavior and a pattern of acts for the federal government. And they say that it's admissible because of this specific act and because he's done this and because of the specific crimes that he's charged with. It allows the admissions of evidence for the purpose of establishing propensity to commit other offenses. So because he's admitted to doing this in the past, there's a propensity for him to have done this in the future. And this is going to sort of be like their way to say he was attracted and doing this years ago. This content was found on his computer, and because we know that there's this history and he's working at this place and no one else at that place has this history, no one else has admitted to doing these things, he's literally the only one that could have been downloading this content. They go through a ton of legalese in terms of why they should allow this, but it says both the offenses charged in this instant case and the defendant's prior conduct that is the subject of the government's proposed evidence constitutes CM as defined by Rule 414. The defendant is presently charged with violations of 18 U.S.C. 2252A, which is contained within Chapter 110 of Title 18 of the United States Code. So he has done things that are under that act where you can admit things into the case. And because of that, they're saying this meets the criteria of what this is designated for. He's done this, and the crimes that he's done fall under this charge and under this law that you're allowing us to apply this to. So for that reason and that reason alone, this should be admitted. And they explain why they would have charged him with second-degree SA. And they believe that the rule here that applies is that there's a high probability that the defendant has an inclination to commit offenses like which he's currently being charged with because he's done it in the past. So it says, indeed, in determining whether to admit such evidence, the Eighth Circuit Court has noted that courts should recognize the strong legislation judgment that evidence of prior S offenses should ordinarily be admissible. So because he's done this in the past, other courts have said we should admit this, and this is why. And because this had children in them, and then the stuff that was on his videos had children and they were around the same age, that's another argument for them as well. So under the Rule 404, they say that it's admissible because he's admitted to doing this to minor girls, and that it establishes that he has motive, intent, knowledge, and lack of mistake in committing the CP crimes. And as noted above, the government anticipates that the defendant will argue at trial that he was not the individual who used his computer to download CSAM and is not interested in such material, placing his own interest in motivations for downloading CP squarely at issue. But their view of this likely focus is the evidence of the defendant's interest in the girls and the prior acts show that he does have an interest in this content. Make sense? They don't believe the evidence is at all prejudicial. And they also say that the evidence is highly relevant to show that the defendant received and possessed the charged CP by pleading not guilty, the defendant has placed his knowledge and intent at issue in case, thereby rendering any evidence of similar prior conduct especially relevant under Rule 404. So because he's trying to say that he didn't do this and he's not interested in this, this is relevant because literally he's done this and it's admitted to it in the past, and he received counseling for it, and he had an investigation for it. And even though he wasn't charged with anything, he would have been charged with a level, it says second degree SA. So their final summation here is that the highly probative value of evidence of the defendant's prior CM conduct cannot be substantially outweighed by any claims of unfair prejudice. Moreover, to the extent the admission of such evidence creates some prejudice, the risk of such evidence being unfairly prejudiced can be easily and properly remedied through a limiting instruction to the jury from the court. So they say, like, approving the use of limiting instructions regarding the prior assaults, or noting that limiting instruction decreases the danger of unfair prejudice. So if they were to give instructions to the jury about it, so they gave the jury a cautionary instruction with respect to how the witness's testimony should be used. This means that they're going to be bringing in the acts that he committed, or they're hoping to bring in those acts because they believe that Josh is going to argue that he's not interested in children and he has no reason to download this content. And they're going to say, no, he has a history of this, and there's laws that say that we can admit this because this is the kind of crime it is. And it's not prejudicial because it's relevant to these specific crimes. Now, the wild thing here is that means that if they have testimony in this case, they could have his sisters testifying. So if he's going to argue that he is not interested in this, they could bring on one of his sisters that he did really awful things to, and that sister might have to testify to court to what happened to her. And that sister will be placed in a really awkward situation and horrible situation where she has to publicly on the record say what happened to her as a child in a case to help the government prove what he's done. And the government is saying that they're only doing this because Josh has already tried to say that he's not interested in kids. So if Josh didn't have that argument, they wouldn't need to be bringing this into the evidence. But they're basically, again, saying, Josh is saying, well, I'm not interested in that. And they're saying, well, you admitted this here. They could also bring in aspects of his own admissions as part of the investigation. So any interviews he might have had with DHS, or any of the documents or counseling records, that kind of thing, they could get access to, and that could become part of the court record here. So we might learn more about what happened in 2006 when they had the case investigated. What kind of services did he receive? What did he say about what happened? Because we have never had the true answer. And this is why I cannot believe they are letting this go to trial. These are secrets and details that Jim Bob has never wanted public. And if they bring this into the court, it's all going to be on public record. I mean, some of it might be redacted, some of it might be sealed. They might do testimony maybe in a closed court. So say if, one of the girls, her testimony might be in a closed court, but it's still part of a case. Jurors are going to hear that. Jim Bob didn't want anyone to know this. And now this could become a part of this case. So for all the people that have been wondering, why do we keep talking about the sisters? This is why. Because his actions 20 years ago are relevant today based on what the prosecutors are saying, because no one else but Josh in that office had a history other than Josh. I don't know how this is going to go. I'm guessing they will have no problem admitting this into the court. In fact, the judge at the bond hearing was very clear that Josh's previous history was going to be a factor. And I believe they have the legal grounds in order to have this admitted. I think it's going to be really hard for his attorneys to argue that this can't be admitted, given that what he did is so atrocious and so in line and consistent with the kinds of crimes he's charged with today. So I'd love to know what your thoughts are about this. What do you think his sisters would feel if they had to testify? What kind of thought process would you have if you were a sister, and how would you, would you be angry at your dad and your brother for putting you in this position? Or would you finally feel like maybe I can get justice? Because in a way, if they're honest and they go on to testify, they could indirectly receive justice for what he did to them, because what they did to him, they believe is grounds for him doing what he did 2 years ago. Like, it's a pattern of behavior. So indirectly getting justice, and it adds a mitigating factor to his case, adding more time to his crime. So it's an indirect way for the girls to get justice, as horrible as that it would be if they'd have to testify. But I just can't imagine putting my sisters through that if I'm Josh, and putting my daughters through that if I'm Jim Bob, if I'm being honest. All right, you guys, tell me what your thoughts are in the comments below. Bye.